Railway Labor Act, commonly referred to as the RLA, was enacted in 1926 with the purpose of addressing and resolving labor disputes between railroad employees and the railroads themselves. This legislation is specifically designed to mitigate disruptions to the nation's transportation network by establishing a structured process for resolving disputes and facilitating negotiations. The fundamental goals of the RLA are to prevent interruptions to commerce, safeguard employees' rights to join and participate in labor unions, and provide mechanisms to resolve disputes involving wages, work rules, and working conditions during contract negotiations. Additionally, it serves to mediate grievances or disputes concerning the interpretation of existing contracts. Rail labor negotiations fall under the provisions of Section 6 of the RLA, which delineates the legal framework for negotiating modifications to collective bargaining agreements. The process under Section 6 begins when both the union and the company exchange their proposed amendments to the contract, a stage often referred to as presenting contract openers or serving Section 6 notices. Distinct from other industries, contracts governed by the RLA do not expire. Instead, they remain in effect with what is termed an amendable date, marking the point when negotiations for changes can commence. This means that the terms of the existing agreement continue to apply until both parties reach a mutual agreement on a revised contract. During the period of direct negotiations, both sides are required to maintain the status quo. Employers are prohibited from imposing new contract terms or initiating lockouts, while unions are equally barred from engaging in self-help measures, such as strikes, work slowdowns, or other forms of job action. At any point in this phase, should either party believe that negotiations are at an impasse, they have the option to request mediation services from the National Mediation Board, commonly abbreviated as the NMB. If mediation is pursued and subsequently terminated without an agreement, the NMB evaluates whether continued mediation will help the parties reach a resolution. If the NMB determines that further mediation will not be effective, it proffers voluntary but binding arbitration to the parties. If both parties agree to binding arbitration, an arbitration board is convened, holds a hearing, and issues a binding decision that resolves the dispute. If either party declines binding arbitration, the NMB releases the parties from mediation, triggering a 30-day cooling-off period. During this period, the status quo is maintained, and neither party can resort to self-help measures. If the 30-day cooling-off period expires without a resolution and no Presidential Emergency Board, or PEB, is established, the parties may exercise self-help measures. Under Section 10 of the Railway Labor Act, if a dispute substantially threatens essential transportation in any region of the country, the NMB notifies the President. The President may then establish a Presidential Emergency Board. The Presidential Emergency Board is made up of 3 arbitrators selected by the President. They then have 30 days to hold hearings and make recommendations to the President. During this time, the status quo remains in effect. After the PEB issues its recommendations, the parties may choose to accept its recommendations, negotiate their own agreement, or, if no agreement is reached after 30 days, exercise self-help unless Congress steps in. Congress has the authority to take the PEB recommendations as written or modify them as they see fit. This new agreement or law will be sent to the President for his signature. Once signed by the President, the new agreement immediately takes effect, and all negotiations in this round are completed.